has appeal in the matter of the claimant, the applicant, Nicola, Shashikanth, and NHS Litigation Authority, amenable.
Good morning, Mr. Auburn.
Lady Board, yesterday Lord Justice Lewis asked for a copy of the direction to NHSLA to form the adjudicative function. We have been looking, and certainly those behind me have been looking, not found yet. It's possible that it's not within the possession of NHSE, or at least anyone that can find it in NHSE, but we have asked NHSLA, I think overnight, because we think they might be more likely to have the direction to them. And as soon as we have anything further, we'll find that.
Thank you very much.
That's all I can say for now. If I can start, unless there's anything else to begin with.
No.
I'd like
do
to
start.
give...
Not no. Do start. There's nothing else.
I got that bit, yes.
No, Mr. Auburn, go away.
One tries to listen to the court when possible, to some extent. I'd like to give a summary of our position. So yesterday I said 3 points, and that was partly looking to the time available and whatnot. But obviously I've reflected on how yesterday and rearranged the notes and so on. So I'd like to. Obviously, I've covered some point on subject matter in Hopley. I'm not going to go over that. You've got that bit. I'd like to start with a summary, maybe about 10 minutes or so, of our overall position and response. So you know roughly where we stand on the main issues, and then source and subject matter, but not repeat, function.
Fine.
And that's my rough map of where I'm aiming to go. But of course, happy to be diverted onto other matters as we go. In terms of the summary of our position, I think the broad approach is probably not in much dispute that you look to whether the source of the power clearly provides the answer, and if not, you look to a range of matters, including function, subject matter, and various matters which have been discussed. And we say that this is not a case where the source alone clearly provides the answer, and there are two basic reasons for that. One, because this involves a mixed picture. There is a statutory scheme, and you've been taken through that, but there are also contractual elements that are important in terms of how we get to the adjudicator on that basis. So it is it's a mixed picture in that sense. And secondly, why this doesn't clearly provide the answer, is the nature of the decision being made being one for the determination of private law contractual rights. And I've mentioned that being bounded by the referral, and that's the scope of the referral. So we say, particularly with those two matters in mind, you can't say that source clearly provides the answer, you stop there and don't look beyond that. And I gave as an example yesterday, one example of Hopley with both the NHS and the NHSLA clearly having statutory sources, but still the subject matter point in the other direction. So that's, in a nutshell, source. And then if you go to that second stage of the multifactorial approach, again, there are two key factors. I'm not saying this is a comprehensive statement of our case, but it's a headline. And it shouldn't be any surprise because we've talked about it before. The two key important points are, one, subject matter concerning private law. I'm not going to repeat that, but particularly the determination here, and I fully accept that there are other cases which will go in, which raise different matters, but in our case, it's a determination of whether a contracting party was entitled to terminate a contract. That's the nature of the decision. That's the first key point on the multifactorial approach function. And the second, as has also been discussed, the elements of election, or the consensual elements. And again, by way of summary and hopefully not a surprise, two elements of election that we discussed yesterday. One, the choice to have a contract comprising private law rights. And secondly, the choice to refer the dispute to the adjudicator rather than sue in the civil courts. And that second election to the adjudicator rather than civil courts, is not an election to opt back into public law, if you like, if that's a description. It's an election on how the existing private law rights are pursued. Because obviously, of the two elections, the first one comes first, second in time, the second one second. So you've got your rights in private law, that's the basis of your relationship. You're making decisions on how you pursue those, and that's the second election. That's the headline summary of our case on those factors, and against that, the appellant points to factors which they say make the decision amenable to judicial review. And I want to, again, briefly touch on those so you know roughly where we stand on that. And I think there are, I always get in trouble when I number things, but I think it's 5 or 6 points which I'll state and then give a response in brief terms. And the first one is that the referral in formal terms is to the Secretary of State in the scheme. And indeed the NHS LA, if we ever get to see this direction, is also a public body in carrying out this adjudicative function. We acknowledge that as a factor in the multifactorial approach. Don't shy away from that. And that these are public bodies. But you still need to look at the particular decision that's being made here.
And do you accept that within those factors, the Secretary of State is the decision maker? It may be something you're going to come to, so take it in your own time.
Yes. Well, the scheme provides for the Secretary of State to do that. The Secretary of State has delegated or directed others to do that. And it's not dissimilar to some cases we'll come to where there is a discharge of an adjudicative function that's cast out to another body. So the Secretary of State could choose, for example, a private law firm.
But it wouldn't matter what you call them. You could call them Paddington Bear. The fact of the matter is, the statutory power is for the Secretary of State, and he may have it decided by an appointed person, like an inspector in planning or anything else. Whom he chooses surely can't affect his powers, which is to determine or to appoint a person to determine on his behalf.
Not his powers, and absolutely accept that those are his powers, but looking at our case, there has been and we also know there is a system in which Secretary of State has that discharged by another party. And so I say that it is relevant to look at that within the overall look at decision making.
But just to be clear, so that I understand, the power is that of the Secretary of State, and that function can be carried out, just using different words,
Yes.
by the Secretary of State.
Yes.
Or that function can be carried out by the Secretary of State appointing someone to do it for him. And so it matters not, in fact, in the scheme of things, whether the Secretary of State thinks he's got time on a Thursday to do it, or whether he appoints Paddington Bear or a firm or somebody who always adjudicates on these matters. It doesn't matter because they're doing it qua him. So it's irrelevant actually whether there is whether he passes that responsibility on, because the responsibility is his and is being exercised for him.
Well, I accept that,
Yeah.
but I will
Good.
also show you how the NHS describes the adjudicative function which they're exercising, and they describe it in terms which stress the independence and describe it as akin to being more like a court-like process.
So you don't accept it, Mr. Alban?
Well,
I'm confused.
I accept that the decision formally is ultimately one of the Secretary of State.
Okay.
So going back to my really simplistic question, do you accept the Secretary of State is the decision maker?
Well, in the statutory scheme, yes.
I mean, if you look at the word, Regulation 82 says refer it for consideration and determination to the Secretary of State. So it's got to go to the Secretary of State. And then 83.5 says where the dispute relates to a non-NHS contract, the Secretary of State may A, determine the dispute, or B, if the Secretary of State considers it appropriate, appoint one or more persons to consider and determine the dispute. But it's clear that the Secretary of State is making arrangements for the discharge of his function of dealing with the reference of a dispute for consideration and determination. The function, as my lady says, of determining the dispute is a function of the Secretary of State.
Yes.
And how he deals with it by doing it himself, if he's free, or appointing anyone else to do it, it is discharging the statutory function under 82.
I accept the function is as Secretary of State. I will still show you the way in which it's exercised, and I say that's relevant to the character and that form. The third point, I think it's the third point, yeah.
So you're
Second,
on
second
yes.
point.
Sorry, second. I missed number there. Second. I always use. Yesterday, my learned friend pointed to the statutory scheme, took you through the statutory scheme for dispute resolution, adjudication, and of course we don't shy away from that. We accept that there is a statutory scheme governing the matter. What we say about that is, in the case that we have before us, which is that of a non-NHS contract, it's a scheme for the regulation of private law contractual rights. And the function here is one of adjudication of disputes of those private law rights. And that function isn't one which is not one which is intrinsically public law in nature. That is, an adjudicative function is not intrinsically public law in nature. It's common to have adjudicative bodies that are not public law bodies. There's no necessary reason why adjudication of private law matters has to be done by public law bodies.
Sorry.
Yeah.
If we're in the opposite stream, we're in the NHS contract stream, and we come to a situation in which matters are referred to the Secretary of State / adjudicator. What are those? What are the nature of those matters? They will be about the relationship between the GP or whoever and the NHS authority. And so although they won't be categorised as contractual rights because you're in the opposite stream, they nevertheless will have the same underlying nature and character. There'll be the same issues, albeit not with a contractual right brand on them. Is that right, Mr. Auburn? Or is what happens down the other route, if you get to mediating adjudication, something entirely different?
What we say is on the non-NHS route, they are bounded by being contractual disputes.
Yeah.
For the NHS so-called contract, they're not bound by that, and they can be any matter because they're not bounded by being a matter referable to the contract.
But they're the
So-
same issues, aren't they? Because they're about the relationship and whether it's broken down or not, and how it is to function that arises between a GP and the NHS authority in question.
Well, the point we make on this is it's that the character of it, non-NHS contracts, is about the pursuit of private law rights. Where that's not the case with the NHS contract. It can be any matter. So I wouldn't necessarily accept that they're the same issues because they could be. Well, once you go out of being bounded by what are contractual disputes about contractual rights and obligations, it can be much broader. So I wouldn't.
But you can test it in this way, can't you? The issue in this case was whether or not there was a breach of an obligation to cooperate with his primary care network. And you say, well, that's a contractual question, therefore, even if the adjudicator is statute, there's nothing inherently public law about adjudicating on contractual disputes. I may or may not agree with that, but that's your position. But what if the day before the adjudicator opened his letter of appointment, not only was there an election to choose the referrer to the statutory process, but there was also noticing, I also want to be an NHS contract now. The issue that the adjudicator is dealing with is exactly the same before he opened his letter of appointment as it is after the letter of appointment. Do the words on the page require the person concerned to cooperate with the primary care network? The consequences of yes, you are required, may differ. You can terminate. If you terminate wrongfully, you might be able to sue. But as my lady says, the underlying issue is, do the arrangements that govern your relationship require you to cooperate or not?
Well, to answer that question, I'll first go back to the previous question I answered, which is I was asked with NHS or non-NHS contracts, are they the same issues or the same different rates? No, I wasn't willing to accept that proposition. But Justice Lewis has now asked me a question about a focused question on a specific situation where they are the same issue, but for the election of NHS and non-NHS contracts. And on that question, where it's framed as they are the same issue, well, I can't deny they are the same issue.
The fact is that that's not this case because there was a contract here, and once there is a contract, the nature of the decision-making process is the resolution of private law rights. And you say that's nothing to do with private law. That's in judicial review, where it outweighs the factors saying it.
Indeed, it was a pursuit of
the pursuit of contractual rights makes all the difference. It balances out the other factors.
Well, I would be cautious about ever saying one matter must come up trumps on anything, because I think that's not the way we look.
But essentially, the key factor here, or a really important factor, is the pursuit of contractual rights.
And the consensual element, the elections.
The consensual element, yes.
And yes. And just to finish off that answer to Lewis' questions, I've talked about the character of this being private rights, but what is happening here after that second election, or as part of that second election, which is to go to adjudicator rather than civil courts, is the active pursuit of your private law rights through a mechanism. Whereas if you've got an NHS contract, you're not pursuing your private law rights. It's choosing this rather than going to civil court.
I assume there's no evidence whatsoever about whether, if one is pursuing one's contractual rights but chooses to go the Secretary of State / adjudicator route, rather than going to the county court, that the Secretary of State appoints a different kind of adjudicator who actually knows something about contracts and the law, rather than an adjudicator being the same kind of person in either case.
It's a relevant question. I'm not aware there's evidence
No, I
before the
doubt
court. And
that.
there wasn't. If there is anything in the bundle, then I've missed it. That's all I can say.
Thank you.
So the point that I was on is
I also add that by that question, I'm not in any way trying to undermine or pour any cold water on the status, understanding and knowledge of adjudicators appointed in this sphere.
I'm sure Jonathan Hadley won't take advantage of the question.
Anyway, you only got to B. Point two.
I'll just finish off.
sorry.
No, it's with the exchanges of obviously covering ground that I would get to later anyway. So just finishing off this B or number 2 on the scheme that we accepted the scheme, but it's a scheme for termination of private law rights. And I was making the point that it's not uncommon, or it is common, to have adjudicative bodies which are not public bodies. That function isn't monopolised by the state in that sense. And the obvious point there is arbitral tribunals. Now, whether or not you're with us on the Arbitration Act point, I'm not going down that direction now, that's for later, but irrespective of that, what you think about that point, we say it's still the case that adjudicative bodies aren't intrinsically public law in nature, because you've got a whole subset of adjudicative bodies which are typically resolving private law contractual rights and not regarded as public law in nature. And the further point on that B of the scheme, or the existence of the scheme, is yes, there's certainly a detailed scheme relating to the operation of these contracts, but also you can say the same thing about the NHSE level decision making, in the sense that the scheme also relates to the way contracting operates between that contracting level, the NHSE or CCG, PCT. That's the level of decision making that has been decided as not being amenable, and this court refused permission on. So it's accepted at this level with this court in Ledger Slang's permission decision that aspect of the challenge, which was an appeal to this court, is not amenable to judicial review. So I make that point because you can also have the same analysis to say, well, look, you've got this statutory scheme that regulates that level of decision making as well. Now, I'm not seeking to make a facile point that therefore they're the same or to be equated, but it's a point about the statutory scheme means or X or points to X. Well, it doesn't necessarily, because it says the same thing about what was refused permission. That's B, or 3. The third point, short one, is the public service context. That this involves provision of healthcare. We all care deeply about the NHS. Decisions about the NHS have a wider effect on other people. I don't seek to downplay the points made by my friend. That's the general tenor of the point: public service context. And in relation to that, 2 short points, which I've already made, so I'll just make sure they're in relation to this point. That one, the decision we're dealing with here is a dispute resolution function, rather than a decision on how someone's GP service is delivered. That's the decision under challenge that you're looking about amenability of. It's the dispute resolution function, adjudicative function. The second point is that the fact that a matter has wider effects or affects other people doesn't intrinsically point to it being public or private, because matters of private law contract can have very large effects. And I gave the example yesterday of Google's terms and conditions. So that's C3, public service context. The fourth point, D, the difference between NHS contracts and non-NHS contracts. And that it may be point against us that it may be anomalous to have a referral mechanism with decisions adjudicators on both types of contracts, and one being amenable and one not. And on that point, you say, well, the two are not the same. Because for non-NHS contracts to go to dispute resolution, there's a subject matter point, which is deciding on private law contracts. And that works the other way with NHS contracts, because it's not decisions about termination of private law rights. So it's not the pursuit of private law rights. So the two are not, should not be equated. And the fifth point, or A, policy concerns. And taking that briefly, I don't seek to mischaracterise my friend's argument. I'm simply trying to not take up undue amounts of time. Because there was stated more than once a point that, oh, well, if we decide amenability one way, or if the court decides amenability one way, that can have detrimental effects of pushing GPs onto the county court, and they might more readily go to the county court. And comments were made a number of times about the cost of that, and it would be expensive to go to the county court to pursue to further contractual rights. Three short points on that. The first point, if a contractor is concerned to make sure that they can do two things, which is have their dispute resolved through the adjudicator and also have the possibility of judicial review thereafter, well then the answer for them is to elect to have an NHS contract. The management of that concern is in the contractor's hands. The second point, in terms of viewing this matter as one of concerns about incentives or disincentives for contractors, the concern about costs of county court and so on, having judicial review following an adjudicator's decision can be a burden as well as a benefit. It's not necessarily only one way. So to the extent that my friend referenced concern about the expense of county court, well, for a contractor having to defend judicial review, that in itself isn't a cheap exercise. So there's no evidence, and I'm not going to go into that, but either way would involve cost, whether you're going to county court or taking or defending a judicial review. Cost risk. So neither are matters without moment or free of costs, risks, or issues. And the third response is that, well, there is, our position is there is a remedy for concern about errors in determination concerning private law contracts. That's the Arbitration Act, again, which we'll come to later. We said that that's the proper fashion remedy because that's the one that relates to the type of relationship we have here. So that's 5 of the 6 points, and that, I think I got the numbering right.
Yes.
So the sixth and last of my overarching points against us and responses. The rule of law concern, there's some overlap. I haven't exactly divided these up perfectly, but the rule of law concern, if I can put it that way, that the appellant characterising our case as seeking to place the adjudicator above the law in some sense, that there would be gross abuses of power that would be beyond the reach of the courts, and hypotheticals were put, and decisions about not contracting with red-headed people and so on. The first point, and I'm sorry for repeating it, but I just want to make sure that it's not missed, that you know our position on the Arbitration Act, which we say is the proper answer to concern about legality. And the route and the grounds you can bring, and you can see that if we get to it, not just the Section 69 error of law, but there is Section 66, Section 67, 68. There are a number of different things you can take to the adjudicator, including excessive jurisdiction and other types of errors. Beyond that Arbitration Act matter, you'll know from our skeleton and also from the exchange yesterday afternoon that we're certainly not claiming that there's no role for judicial review. Now, I don't want to get tied up on what the heading of our section of the skeleton should be or not, whether it's amenability or part amenability or whatever, but we've never shied away from that because we've always embraced that support-ways line of authority and how it's put, whether you put it as the moniker fraud, corruption, and bad faith, or whether it's something like let's bound it. But we did say yesterday that there is this formulation that's been used in past cases. Equally, I made the point yesterday that shouldn't be read as a statute. There will be others. What we have in this case, and that's what I think is important, is I understand the need and the desire to look at hypotheticals to see what the terms and the breadth of the proposition may be, but this case is about an adjudicator making a decision on the termination of contract, which the appellant says is wrong, because they say the adjudicator should not have held that the termination was correct. So this present referral, which is what this case is about, is one which concerns purely the determination of private law rights. Now, yesterday I was decidedly cautious about how far I extend beyond that, which is beyond the facts of our case. But I understand the wish to consider other situations for this. And I did acknowledge yesterday that there can be, certainly we know the grounds themselves are a matter to take into account in determining amenability. So the nature of the grounds can have a particularly public law element, which is a weighty matter. And I think that's what partly lies behind that support-ways line of authorities, because those types of grounds about fraud, corruption, and bad faith are matters which convey we'd bring a public law matter in. And we say that our case is not that case, it's very different to that case. But equally, I don't wish to say that categories are closed or matters are bounded because a certain term has been used before. And yesterday, Lewis asked me the question, well, what if the adjudicator breached in this case, was his own procedural duties under the regulations? And we've looked at the regulations before, and we know there are many procedural steps. You've got to make sure you send things out. You've got to make sure that if one party gets things, it's copied to another, and so on. So there are various steps from the regulations which have to be complied with. And while I was loath to answer other cases or other situations which aren't ours, I can see that you've got a stronger case for the element being of more of a public nature, where it is an adjudicator breaching a procedural duty under the regulations. In any case, you'd have to look at the multifactorial analysis. You can't get away from that. You have to look at all matters in the round. For us, that's not our case. And that's all I need to say. That is the summary of our case. I now propose to move on to source and function, which, by virtue of the particular cases I want to take you to, they cross over because one case concerns more than one issue. But before I take you to the cases, I just want to briefly touch on small bits of the regulations and contract. You were taken through them as a whole yesterday, but I want to just draw out one or two items without going over, in no way repeating the exercise. And it's about 2 items from each. So the regulations authorities bundled. I'm going to give it a page number to go directly to it. 110, which is the 2015 regulations, Reg 10. You've seen this before, so I'll take the matter quickly. This is the provision about election between NHS contracts, non-NHS contracts, through the mechanism of whether you're a health service body or not. You've seen how that operates. The only other regulation I want to take you to, which...
Can I just understand Regulation 9 again? Is 9.1 for negotiations intending to lead to a non-NHS contract, and that is referable under 9.1, and 9.2 is just noting that an NHS contract can be referred under the provisions of Section 9 of the Act. Is that what Reg 9 means? Or put differently, what is Regulation 9.1 dealing with? Is it dealing with the negotiation of a non-NHS contract? I'm just looking at the definition of contract now.
I'm afraid I need to look.
Definition of contract.
Yes, that's one.
Definition of contract made under Section 84(2) of the Act. So you turn
Contract is a general medical services contract.
Yeah.
And
that
Hey,
is the non-NHS contract. So 9.1 is negotiation of a a situation that will lead to a binding contract then, I think.
Well, I think that might be right, but I might need to look at it a bit further. I apologise for not giving an immediate answer to that.
Worse than the judge suddenly reading regulation carefully.
Yes, it's not a point specifically I'd looked at before, and you have to consider a number of provisions together to give a confident answer.
Things, yeah.
Yes, I apologise for not giving that immediately. Reg 32 is the only other provision I wanted to take you to.
So what was your solution about? It's my fault entirely, because I was trying to work out what it meant. I didn't note down what you said the significance of that was for this case.
I apologise.
No, it's my fault, because I was just on a goose chase.
I'm simply showing you the provision which contains the provision about the type of that election, that first election. And then later on I want to show you where you see the election on the page physically in this case.
Okay, sorry, my fault, yeah.
Now the only other provision is authorities 1, 2, 3. So I'm not making grand points from these. I just wanted to cover particular points which I thought were dealt with in this case briefly. 1, 2, 3 is regulation 32. And this is paragraph 2. A contract must also contain provisions which are equivalent in their effect to the provisions in these listed parts of regulation. So this is the basic provision about the scheme providing the content of the contractual terms, and that's where it gets forced from. And what I say about that, and I suppose the submission on the back of that, is where, as here, you have a non-NHS contract. What Regulation 32 is doing, its operation, is to just prescribe the terms of things which have effect in private law. And the submission, if you like, from that is the content is directed by the regulations, but that doesn't change their nature as being terms which are private law contractual terms. That's the submission. The scheme directs the content, but we know the name. They still have that nature or character. That's only just briefly two regulations. I wasn't going to go over all of them. Equally, on the contract itself, in a similar vein, we have to go to the supplementary bundle to that. Factual bundle, supplementary bundle. Page 31. Page 31, you should see part 3, NHS contract, clause 14. It's clause 14 of the contract, and this we say is the election. You can call it a non-election or a negative election or whatever term you want. That's form rather than substance. In substance, this is the election for the type of legal relationship. Here, Dr. Shashikanth choosing to have this form of relationship rather than a different clause which would have led to a different relationship. And then the only other provision of the contract is on supplementary bundle, page 80.
89?
So, no, I'm sorry, I was about to, I think it's 66. I'm sorry.
66.
Yes.
thank you.
Which is at the bottom of 66, if you can see it. Dispute resolution, non-NHS contracts. Clause 521, 522. 521, any dispute arising out of or in connection with the contract, except matters under other matters, referred to consideration if PCT so wishes and contract as agreed, or contract so wishes, even if PCT does not agree. And in 522, agreeing to be bound. I make 3 short points on this. It's the parties exercise, well, the contractor has a monopoly of choice here by virtue of the 522.1 and .2, but the contractor's choice under the contract that leads to the particular dispute being referred. Second point is that the jurisdiction is to determine a dispute. Rather than a wider evaluation of the parties' rights and obligations.
This doesn't give the adjudicator jurisdiction at all. This makes it clear it's at least a contractual, like not a breach of contract, to ask or refer a matter to the adjudicator. The adjudicator could send it back as well. That's very interesting. Nothing to do with me. It's only because of the regulation. That's the point you've got to address.
Jurisdiction is possibly not the right word.
Yeah.
This is the mechanism which creates the referral.
Ah, yeah. Well, this is the mechanism within the contract that provides for a referral, yes.
And does it by reference to a dispute.
Yeah, thanks.
And the third point is it's a dispute as described, that's only one arising out of or in connection with the contract, which is this contract.
Strangely, the footnote on page 66, footnote 82, which is after the heading dispute resolution non-NHS contracts, says these clauses are mandatory terms only if the contract is not an NHS contract, otherwise they should be deleted. So presumably in an NHS contract, these provisions do not apply, do not occur at all. But there must be some dispute resolution terms, I use that word with a little trepidation, within an NHS contract in order to get one into the situation that, whether you call it a dispute or whatever, does get adjudicated. I was just thinking that that would be helpful to you.
Yes, that's how I understood it anyway. So I was about to respond, but if something being pointed out to me. Thank you.
Oh, actually, no. Sorry, Jonathan, that's not helpful at all.
What I was going to say, thank you, that's fine. Well, what I was going to say in response to my lady's point is that footnote 82 is obviously there for a reason, and the reason is there's a difference between the two types, or at least that's what it's going to. Footnote 82 is identifying or going to a difference between NHS and non-NHS contracts. Exactly what the terms that are is another matter, but it's there because it's identifying a difference.
As if you didn't have enough to worry about, Mr. Orban, I then read footnote 81, which says, except as specifically indicated, this part, and this part is the dispute resolution, i.e. the requirement to have a choice to go to the Secretary of State, is required by the regulation, see Part 7 of Schedule 6. In my excitement, I turned to what are the 2015 regulations, and I turned to Regulation 6, and I was horrified to see it doesn't exist. So this must be a reference, and to be asked to say what that means when nobody's ever thought of it was very unfair. You don't happen to know from an extensive knowledge.
Well,
Oh, you do.
well,
you know,
someone
you're reg-
may is about to whisper something in my ear, so if I can,
Oh, right,
if I
we
can
don't
be
know.
given a moment.
I'm sorry to interrupt
No,
it.
no, let's say to Mr. Orban first. Through the stages.
Right, if I can just take the point, please.
So, as Reg 32 requires these terms in the new scheme, and there was this provision required these terms in the old scheme.
My junior believes that this was a reference to this is picking up the equivalent of Reg 32 in the old scheme, or in the previous regulations.
So is there anything in the new regulations which says you must, statute saying you must give a right to the NHS dispute resolution? Is that also required by the new regs? So there's a statutory requirement to give a contractual choice.
Reg 32 says,
Then it's a bit harsh.
If I can have just a moment.
I've mastermind really, and the clock is ticking.
Okay.
Did you see my problem, do you?
well,
Maybe it isn't there in the
Authorities.
schedule, because it's oh hang on,
Authorities 123,
yeah.
page 123. Which is Reg 32.
Yeah.
Subject to paragraph 2, a contract must also contain provisions which are equivalent in their effect to the provisions set out in part 6 to 14.
Mm-hmm.
And the footnote is saying, except where specifically indicated in the footnote, this part is required in the regulations. See, and I think that looks like, yeah, within the bounds of what Regulation 32 is referring to.
It looks very quickly as if in the old world you had a statutory requirement in the schedule to have a contractual provision about electing, but it looks from 32.1 and 32.2 of the new regulations that there's no requirement to have a right to use the adjudicator process, because that's actually in 84B. That's why there's no requirement to have anything equivalent to Regulation 84. The requirement to have a contract does not apply to 84. I think that's how it works. So it is not required to have it in. It's a matter of the parties putting it in, or it's more likely to have been carried over from previous practice. Do you follow me?
Well, you may well be right. You may, but sorry, but I'm not sure about that
It would help you
because
though, yes.
because the if I can just have a moment. Within 32.1, it also covers the first parts of Reg 83 because they're not excluded by 2A. And it, yeah, thank you, and 82. So if you look at 82, Reg 82 and the first parts of Reg 83 are required to be included. And if you look at those,
Oh, yes, they are then, yeah.
does that make sense?
Right. That may help me then, because if there was a statutory requirement to have a contractual thing, Mr. Shashikanth will be saying that supports his case. But if it really is an element of choice, they don't have to put that into the contract. You would want to say that supports your argument that it's all to do with anything goes, people can choose what they like. If you follow me,
Yes.
it helps you.
Yes. Yes. I can see the point can be argued both ways.
So I'm obsessed with the law, and occupational helpers.
Well, it might not be the worst quality in the Court of Appeal judge. That's the referral mechanism, and the submission is a short one, which I made before on that. So I've taken some of the regulations and with the contract. And the point really again is it's a mixed picture. That's the submission point on it. I'm not going to.
Mr. Orban, before you go on, Mr. Shashikanth wanted to say something. Has the amendment passed?
No,
No.
was an attempt, probably incorrectly, to explain why the clause in the contract at page 66 in the supplementary bundle 521-2 are to be deleted in a NHS contract, because it's headed dispute resolution non-NHS contracts. And then at 523, there is a dispute resolution procedure for NHS contracts. So it's simply saying delete it in non-NHS contracts, but there's an equivalent referral mechanism in the next clause. That's why you have one or the other. In a non-NHS contract, you need both, because 521 and 522 then adopt the procedure in 523. But in a non-NHS, in an NHS contract, you obviously delete 521 issue. I don't know if that's at all helpful.
Thank you. Mr. Orban.
The only, I'm grateful for Mr. Sachiva on that, and I'm not sure it does help us with our online case, but
I'm sorry, I haven't mentioned the footnote.
it's all useful. What Mr. Sachiva shows you was the procedure provision rather than the referral mechanism. So it may be that further investigation of that point needs to be, I'm not sure we have bottomed that out actually.
No.
The submission on the back, so I've taken you through, just to catch up where we were, taking you through a couple of the regs, a couple of the terms of the contract, and the submission on the back of that is it's a mixed picture. Certainly statutory scheme, but certainly also with elements of contract which are relevant to the position. And tying that up with what I was saying yesterday, I was talking about subject matter and showing you the case of Hopley, an example of a body with a statutory source making a decision under a statutory scheme, but because of subject matter, management of a tort claim, that points away from amenability. So the point about it being a mixed picture, you need to look further. The last point before I go to a case on source and then function is in terms of source. Yesterday, my learned friend made the point that, again, I'm not seeking to put words in his mouth, I'm simply, you'll have your own notion of what he said. I'm not seeking to characterise in any other way, but he made a point in general terms that the statutory scheme here and the detail of that pointed towards amenability. A point he said was in his favour. And the point we make is you can have statutory schemes which also serve as the basis for a scheme operating at the opposite end of the spectrum, namely arbitral functions. And that's not in itself a shock or a surprise that you have statutory provisions creating arbitral systems. And a very short point to make, authorities tab 4. Again, I don't seek to elevate the submission to any great height. It's a simple point. Authorities bundle, page 40, shows you that there's a whole other range of schemes or bodies with statutory arbitrations. That's 94, 95, 96, and so on. the Arbitration Act applies to statutory arbitrations on these pages here and following on. And I only take you to this for a simple point, which is that it's not the case that having a statutory scheme of itself points to amenability, because you can have a statutory scheme which is at the other end of the spectrum. But I'm just in the way things have been discussed in cases, in amenability cases, in terms of the spectrum. Having made those points about source, and we've gone around about source, it's still important to note that courts have warned about focusing too narrowly on source, because there are other factors, and only in the first cases do you shut out consideration of the wider circumstance. And it's that point of not focusing too narrowly on source, which leads me into the first case this morning I want to take you to, which is Holmcroft. And it also goes into function. And that's, Holmcroft is at Authorities tab 69. We said the case is useful in the present context because it concerned private law disputes, and where you had a third party decision making, as in some senses you've got in our case, and certainly decision makers isn't the contracting parties. The adjudicator here, indeed Secretary, was not a contracting party. So it's useful to look at a case of that nature, as well as the fact that it's a relatively recent Court of Appeal authority. And I'm about to dive into it. Just before I do, I'll sort of give you the headline of what I think it shows, or assists you on. It assists you because it's an underlying framework with a statutory component, regulatory requirements issued by the FSA under Section 166 of the Financial Services Markets Act. And there is a sense in which the relationships have contractual elements, including KPMG, the decision maker, their contract with the bank, with Barclays. I'll take you.
I didn't get that. This shows there's an underlying framework with a statutory component, but I don't have what it shows.
Sorry, the situation was one involving an underlying framework with a statutory component. So that's the
It wasn't
broad.
subject to JR.
Yes.
Yeah, okay. So it shows that underlying framework with the statutory component does not necessarily mean it's automatically JR.
With the contractual element as well. And
It's not JR then.
and the Court of Appeal emphasising the need to look beyond the focus on source. Now, I'll give the general caveat with all the cases I take you to that, well, maybe apart from one, very few of them are identical. And that's the nature of dealing with amenability. To take you through, apologies if I, to some extent, skip over, but starting at paragraph 1, 1 and 2 show the system woven into a statutory scheme for financial regulation, customer redress arrangements set up by the FSA. And then the end of paragraph 1, the FSA was until 1st April 23 the regulator with statutory powers of the UK financial services industry. And then 2, as part of the redress scheme, Barclays voluntarily agreed with the FSA would provide fair compensation, and that led to the skilled person mechanism. This is appointment within the statutory scheme in reference to Section 166 of the FSMA. Barclays appointed KPMG, so that's one of the contracting parties appointing that KPMG as the skilled person. And 3, Appellant Holmcroft was a customer of Barclays, said that the interest rate, IRHP, interest rate hedging products, they were mis-selling. Barclays offered Holmcroft compensation under the redress scheme, this is paragraph 3. The offer did not include compensation for certain consequential loss. So there was a debate about whether the compensation offer should have had consequential loss. It's about the terms of compensation for this mis-selling. To which Holmcroft considers entitled. KPMG, as independent reviewer, made an AFR assessment. So thank you. I was just looking for where it is in the paragraphs, but AFR, appropriate, fair and reasonable assessment, approving the offer. Holmcroft sought to judicial review the decision to approve the offer on the basis that it failed to discharge public law duties of fairness. So you see the nature of the ground. Or public law duties of fairness. And then paragraph 4 is a divisional court decision, not amenable, that's in the 4th line. So the divisional court decided the decision wasn't amenable. I'll to some extent skip over some of the detail, but I'll at least identify where it is. Paragraph 7 has the mis-selling and redress scheme. Paragraph 8 has the redress and the decision of the independent reviewer. And then we go to judicial review. In paragraph 10 is the divisional court's decision. And divisional court accepts some points in favour of amenability. So paragraph 10 woven into the fabric, assisted in performing regulatory function. And however, weighing up both factors, the role of independent reviewer does not have a public law flavour. And 11, divisional court gave 5 specific reasons. Summarised: first, Barclays' implementation of the redress scheme was essentially voluntary. And then, so I know that aspect. And then going on, it gives other reasons which I'm not going to read out because it's a divisional court and we'll get to the Court of Appeal. In any event, you've got, over the page, you've got long quotes from the divisional court judgment giving all the different considerations of factors which led them to conclude it wasn't amenable. If I can then, I just note over the page that Aegon, YL, a number of the classical authorities are discussed, so just to point out this isn't a case which decided without consideration of authority. And then, yes, I think I'll skip over to the conclusions on judicial on amenability, which is at paragraph 38. We've got 38. Having considered the parties' submissions, conclude the reasons given the divisional court was right. Conclusion for holding that KPMG was not amenable to judicial review. At the same time, I consider the divisional court may be said to have focused too narrowly on the source of the independent reviewer's powers. This is a point I raised before about one should be careful to focus too narrowly on source. Because obviously it's a multifactorial approach as well. Consider authorities. 40, the authority cited demonstrate, divisional court pointed out. Fact decision emanates contractual arrangements, so that was the focus too narrowly on source there. Does not mean public law principles are inapplicable. Question is whether the body carried a public law function. And then 42. Despite the fact the legal source of the power was merely contractual and private, its functions were hybrid, partly public, partly private. court concluded the panels. This is data fin, by the way. In reaching this conclusion, the court looked beyond the mere source. So I highlight that to show this thread of don't focus too narrowly on the source, the exclusion of other matters. Then 43, unlike data fin and Agon, unlike data fin, Agon concerned the compensation scheme, statutory recognition, so it's going through Agon there. And then I think I can skip to 45. Agon is the closest for the authorities. Pre-existing voluntary arrangement for customer redress. On the other hand, there are important differences. And over the page, 47. Cites beer. It's important because it summarises jurisprudence on amenability, makes it clear that all the circumstances relating to the nature and function of the power are relevant, and then it gives the beer approach, which you may have seen, and then again, 48, the point about the divisional court focusing too narrowly on source.
The impression I get, having read through very quickly, is that the criticism on focusing on source was because this was originally began as a voluntary arrangement, and because the source wasn't statutory, you shouldn't assume, therefore, as a non-statutory body, whose powers were not sourced from statute, that it couldn't be amenable to judicial review.
Yes.
Slightly different from our situation.
I fully accept it's converse, but the point is nonetheless a relevant one, that there's a danger in focusing too narrowly on source.
Your earlier point that even if it is a statutory process, and this case wasn't, that the nature of the decision may indicate that that particular decision is not a public law decision.
That's really why I
saying, yeah.
took you to these passages. And then, just about there, paragraph 50, if you can see at the bottom of 1404, analyse the position of the skilled person as part of a wider regulatory context, necessary to stand back and examine the function filled in the so-called voluntary settlement. And then it talks about the extent to which that can really be said to be voluntary, makes points on that. And then 51, turning to the relevant factual context, should be viewed more widely, similarity to the scheme. Of course, I can't claim that any case is so similar, so I don't want to get too into detail of each specific point. So I can just take you to about 6 lines down of 51. There were 2 different features in this case. First, the industry regulator, the FSA, imposed the obligation on banks to grant redress. And second, the regulator required banks, Barclays, to engage the civil person. So those pointed to amenability, those factors. Those were the pro-amenability factors. But, and the but then comes in paragraph 52. These features, however, do not alter the nature of the scheme, which is essentially the pursuit of private rights. Now, I don't want to be accused of plucking a sentence out of context, so I'm carefully taking you through as much of the case as you may bear, but you'll know what we say about this. And in fairness, paragraph 52 is the Court of Appeal's analysis of, because they've just gone through factors pointing to amenability, and now they're going the other way. These features, and that's the however, however, do not alter the nature of the scheme, which is essentially the pursuit of private rights. And in our case, again, I don't want to overplay matters, but our case, the adjudicator, non-NHS contract was pursuing, the contractor is pursuing private law rights. all the determination of the private law rights through that adjudicator mechanism.
But it's quite important to read the remainder of paragraph 52, particularly from about 1, 2, 3, 4, 5, 6, 7, 8, 9 lines up from the bottom.
Yes, I hadn't finished, but entirely agree. Is this nothing to suggest that there should be any challenge on public law grounds to the issue of confirmation? The compensation was moreover to be negotiated on private law principles. I'm not sure if that was the part you're looking at. That was the next part.
Yes.
Yeah, that was part I was going to take you to. Private law principles, limitation, heads of recovery, damage, and causation, and compare that to our case where I accept we can look at other types of decision or other hypotheticals, but the actual decision in our case was about termination, was a termination decision right, exercising of contractual rights. So I draw a similarity from that.
But then it goes on, the FSA did not aim to remove the role of the courts in enforcing civil claims, and its regulatory function did not extend to replacing the role of the court. Far from being neutral, the fact that the engagement of the independent reviewer was contractual was all of a piece with the fact that it was not performing any public function.
Yes. Yes. Again, I have touched on submissions about remedy, and I'll go back to that at a later date. I'm not saying each case is exactly the same. There are differences, but in our case, remedy there's a different answer to the issue of remedy. It's a choice of how you enforce and options for that. 53, the reality is that Homecroft's bringing of a complaint against KPMG was ancillary to pursuing a private law claim. Requirements of SA merely overlaid set alongside a private dispute, not change the character of that dispute, which is fundamentally a private law matter. And I'm not saying that all of that is exactly the same here, clearly not, but the broad point I make is looking to the character of the dispute, it's fundamentally a private law matter.
And that's also emphasised in paragraph 55, 1, 2, 3, 4, 5, 6, 7 lines down, where Lady Justice Arden, as she then was, says, however, the customer would be free to reject the offer. This is about no means of redress in public law, because you can reject the offer and your legal remedies against the bank would remain unaffected. So actually, you're not going down a cul-de-sac, you're going down a possibility of gaining compensation. If you don't like it, you can go back in any event to the legal system.
Yes. And we have different things to say about remedy in our case.
Yeah.
That's useful, thank you. So I didn't skip over that case too quickly, but I think it's important to cover because what I take from it, obviously it's a relatively recent Court of Appeal case. With things to say both on approach to source, which I've covered, including with Justice Lewis, and particularly the subject matter and decisions on private law, contractual rights. And in this case, there were clear aspects pointing to a public nature, without doubt. A body appointed within a statutory regime, the whole regime of the FSMA, Financial Services Markets Act, a scheme established by the FSA. So all these things are public pointing, if I can use that phrase, determining redress arising from regulatory breaches, which is misselling. All those significant public aspects, the result still was non-amenability, but the reason for that, or at least important parts of the reasoning of that, are the descriptions of the fundamental nature or character being the pursuit of private law rights. That's what I call subject matter. And that subject matter, which is the point I started on yesterday, you can still have regulatory requirements underlying the determination, but they don't change the character of the dispute as being one which is a fundamentally private law matter. And again, not wanting to be accused of overplaying cases on different facts because they're all different, but there is a similarity in that the referral to the adjudicator was essentially the pursuit of private law rights. And the character of the dispute was fundamentally a private law matter in our case. And I think those tie in with those paragraphs of Homegroff we were looking at, 52 and 53. And in our case, the appellant was saying the termination notices were a breach of a contractual requirement in private law. The application or the transfer of Homecroft as to how we transplant that into our case is also set out in our skeleton paragraph 69, if you want that for your note, where we say from Homecroft we take these, and this is how you can apply that here on our case. So I wasn't going to read that out, but I'm happy to look at it if this is. Finally, very briefly, because I don't have any reply to the reply, so I need to say what might be said about Homecroft, Beimel and a friend, that all I know is what has been said previously is it's a case concerning an accounting firm rather than one ultimately concerned or going to the Secretary of State and Secretary of State's powers. Now, again, I acknowledge that difference. I don't magic away differences. Notwithstanding that, the similarities are important, and again, those are set out in the skeleton, paragraph 69A. To summarise, both Homecroft and this case have a contractual and statutory mix in the underlying decision-making framework. Second point, the issue about not focusing too much on unduly on source of power. I take Lord Justice Lewis's point, but I think the point is still, the general point is still a good one, that one does need to look at other matters as well. And then the third point is the critical issue, and the word I think used in the judgment was fundamental, but it's not a side point. It was the character of the dispute which the decision maker was deciding upon. Is of a similar character. That's Homecroft. Useful for the point it makes about source, but particularly for what it says about subject matter or function.
It doesn't really matter, but so that there's no confusion about language, because subject matter is used sometimes in relation to anything else. The one question really is whether, although the source has a statutory source, or although it's a mixed statutory contractual source, it's whether the nature of the particular decision is such as to qualify as a public law decision. So it's the nature of the decision here, you're saying. The subject matter can be misunderstood, because that means when you try and sue it for a contract right against a public body, and even if it's a public body, even if it's normally amenable to judicial review, if you're trying to enforce a contractual right against it, like the termination notices, you can't do that. And subject matter is usually limited to that, because then you get into the discussions we had yesterday about subject matter of the dispute or of the JR. So it might be helpful to have an agreed terminology, as the technical writers do, and say the nature of the decision, notwithstanding its source, is not of such as to be a public law decision.
Yes.
And you don't disagree with that?
I entirely agree with everything you've said, and happy to adopt that terminology. I have been using different terminology, so if you're going back to your notes, you might need to be careful about that. Because I wrap up grounds of challenge, because I think grounds of challenge are relevant. I've said a number of times, the nature of the challenge, the grounds of challenge, are also something you look at in determining amenability. It might seem initially an odd thing, but it's discussed in cases, and we know them if needed. that can be relevant.
Which of the decision and the challenge then?
Yes, previously, yesterday, I took them both under subject matter, but I accept lots of terminology. So Holmcroft was a decision about a decision maker that wasn't the contracting party, the third party decision maker, if I can use that terminology. The next case I want to take you to is also another case where you've got a non-party, a third party coming in, making a decision on private law rights, and that's Western Lloyd. And I'll just, thank you, tab 64, if I can just give you the headline or why we're going to this. So you've got some sense that your time might not be completely wasted. I think what you can get from this case is it's a case where decision makers' power stemmed ultimately from a private act. I can use the word statutory, to be clear, private act of Parliament and bylaws. The decision challenged concerned commercial relationships governed by a contract voluntarily entered, and the working out of private contractual relationships, private contractual arrangements. And the headline decision is it wasn't amenable. Now that's a very short summary. I'm going to take you to the case. The issue is at paragraphs 1 and 3. During West issued judicial review claim, sought to impugn for decisions of the Business Conduct Committee. So the decision maker here there is BCC, Business Conduct Committee of Lloyd's, to approve minority buyouts of his memberships. And the issue is also discussed at paragraph 3. It needs to be stressed that the case is concerned only with functions performed by the Council of Lloyd's and its committees when they're exercising regulatory powers in relation to the affairs of members of Lloyd's and other peoples. At the end of that paragraph, not concerned with the exercise of disciplinary functions. That's the distinction they're making, because there were also disciplinary functions, but we're not dealing with that. Who Lloyd's are is explained in paragraph 4, Association of Insurance Underwriters. 5 is the Private Acts of Parliament, Lloyd's Act. And 7 talks about external regulation of Lloyd's. Then 12 and 13 need to go to. You can see here 12 and 13, you can see the parties to the process. 12, decision which Dr. West seeks to impugn made by BC pursuant to the MST bylaw, and then describes that decision, approval of particular bodies, managing agents, and so on. And then 13, third and fourth decision, approval of proposal to do certain things. And 14, the grounds of the complaint.
And just why was approval necessary? Was it in the Private Act of Parliament, or was it?
I beg your pardon, Lord.
Why was the approval required? Was it required to the Act of Parliament, or?
29.
Thank you. Paragraph 29. Lloyd's derived its powers from an Act of Parliament. And the rules are referred to in paragraph 11, which is the minority buyout rules, transaction bylaw, or the MST bylaw.
That's a submission. I think it's 8, 9 and 10 actually. It's unhelpful, but it looks as if there's a contract, and it looks as if in paragraph 9 there were changes to what it calls the regime. So I don't know whether it's the contract or the bylaws. Unless a G9 says to the introduction of a new regime, but it unhelpfully doesn't tell us
Yes.
what the nature of that regime was. But it looks as if it's in the contract. So they've got they exist by statute. They've got a power to make bylaws, and a date there's a contract, and the contract says that it's got to observe all the bylaws.
Yes.
And then at 9, without saying what the regime is, by some mechanism, either the bylaws or the contract, they've got to get approval.
Yes. 9 isn't exactly on that point, but there is a combination of both elements that get you to
Yeah.
this point. And
Before we go on, I think
oh, sorry.
I may have the answer. Paragraph 11, I think the requirement seems to arise from the bylaw in the bottom 2 lines of approval of the council. I think that's why the approval of the council was required for the buyout.
Okay, so the power is in the bylaw that they have then. So they've got a statutory power to make bylaws, and the bylaws require the approval of the council, and they enter into a contract that says they've got to comply with the bylaws. Is that it?
Thank you very much.
Thank you.
Sorry, I'm being difficult, but it's just to get it accurate.
So in fact, it's a combination of paragraphs 8 to 11.
Yeah.
Yes. And the grounds are 14. Lack of access to right of appeal, inability to sue the council, negligence, mistake and bad faith, wish to invoke provisions of the protocol. If laws not excellent public functions, these avenues of complaint will not be available. And then 21 is the new regulatory regime, which is at 21 to 24. The arguments on amenability are at 27 to 29 are the claimant's arguments as to why it's amenable, data fin, and particularly 28. Well, 27 is its governmental function, 28 is the public element from the functions under powers contained in the bylaws, 28 deriving its powers from Act of Parliament. So these are the arguments that are put as to why this should be amenable to judicial review. Again, I want to be clear, I'm not suggesting there's exact parallels, but there are flavours or combinations or some similarities. What's important is the ruling. So just to be clear, you've got, because the rule discusses the arguments are 27 to 29, so you've got those. And then the ruling on amenability is paragraph 30 onwards. So we have to unpack that briefly. I cannot accept these submissions. So those are the submissions of Mr. Nundell as to why it should be amenable. The fact that Lloyd's corporate arrangements are underpinned by a private act and not by Companies Act makes it in no way unique, so certainly not dispositive of the matter. Fourth line down, entirely satisfied the line of case at divisional court level, which relates to private law status of Lloyds in relation to functions such as those in issue were correctly decided. Logic behind them is unassailable. So the point there in 30 is that, as I read it anyway, that's the fact that there's a private act of Parliament or the underpinnings weren't determinative either way. I raised that point because it was said yesterday, oh, well, you can forget about this case because it's a private act of Parliament. But actually, if you look at the ruling on amenability, first point they deal with is this private act of Parliament bit, this source bit or underpinnings bit. So, well, actually, no. The reason why, the court's reasoning as to why it was decided this way, not amenable, is 31. The decisions under challenge were concerned solely with the commercial relationships between Dr. West and relevant managing agents. This was governed by the contracts they had chosen to enter. Those decisions were of a private, not public nature, consequences in private, not public law, Tucker, which is one of the cases we rely on.
And there's reference in 30 back to Lord Justice Leggett, as he then was in Ex parte Briggs, which is set out at paragraph 17 and was also set out in Holmcroft in the judgment of Lady Justice Arden. And there you have a crisp explanation of the position of Lloyd's, and in that case, the fact that actually what was being pursued were rights relied on which exclusively arose in contract. And you would say, same here.
Yes. And that is the point that 31 is getting to. That's the core of the reasoning why it's wrong to say private act of Parliament, therefore you can figure it out Lloyd's. Actually, that's not how this works. It's that point which leads on to 31. And then just to finish off, I think we're done. 32, no discourtesy to Mr. Ardell, further any more of detailed submissions. Third line, functions of Lloyd's under review, totally different. Each of these cases is different, except that. And then talks about data fin, panel, exercise, takeover panel there, I think that is. This case is concerned with the working out of private contractual arrangements, Lloyd's, which is itself subject to governmental regulations. So, again, each of these cases is different, but look at what the Court of Appeal is focusing on here. It's the working out of private contractual relations, notwithstanding there are a number of other elements which would otherwise point to amenability. There is discussion of other matters and human rights matters, but the conclusion is at paragraph 40. Not amenable judicial review. Now, why have I spent time on this case, or what you can take from it, why it's useful, given that each of these has different mixes of factors? The similarities, the underpinning, private act of Parliament, which are exactly the correct terminology to use for that on a public nature, but it's not a contract, I'll put it that way, private act of Parliament. It's, I would say, it's statutory in a sense. The decision-making process here had a third-party decision-maker, not the parties to the contract. The subject matter, I'm sorry, those are my notes. I've got to pay.
Nature of the decision.
Thank you. The nature of the decision was contractual, commercial, about the contractual relationship between the parties, and that's what the Court of Appeal looked to. Is about the relationship governed by the contract they'd chosen to enter, and that's again that is the focus, and that's why they were of a private, not of a public nature, and the fact that those private contractual arrangements at Lloyd's were themselves subject to external regulation wasn't enough to make it amenable. So I accept the difference of being a private act, but that was within the argument as to why amenability, the argument for amenability was rejected. So I don't think that is enough of a basis to dispense with this case. So if I can then recap on what I think what I submit can probably be taken from that. I've taken you through 2 Court of Appeal judgments, Homecroft and West, both involving third party or separate party decision makers making decisions or resolving disputes about private law relationships governed by private law. And I've endeavoured to show you the way the Court of Appeal have approached that type of situation. Now, to very briefly apply that, because I think you'll know pretty much where I'm going with that. So I'll be brief, but I want to take you to one document. To apply that to our case on the nature of the decision, what we say about character. And you can look at it, picking up from my earlier discussion with Lord Justice Lewis, you can look at it both from the character of the decision under challenge, what that related to, and also the nature of the grounds of challenge, to the extent it's also relevant to look at that. I say both of those concerned issues of private law rights. And to do that, I'll just go to one document, which is the adjudicator's decision. And I can just show, I'm not going to take you through enormous detail because you will have seen it, you've been taken to it. I just want to flag up where you can very broadly see the point I'm making on the page. And that's the end of the core bundle begins at 355, 356.
I'm sorry, I didn't hear that. We're in the core bundle at?
Core bundle, the end of the core bundle.
Yep.
355 is the cover page. Starts at 356. I'm only going to take you to a few pages of this. I'm not going to give you all the detail because you will have read it before. This is the decision made by the adjudicator, Mr. Jonathan Haley. And at bundle 357, 3.1, you can see the heading consideration by letter dated 24 September. Commissioner notifies the contractor of decision to terminate. By another letter, Commissioner notified the contractor of decision to terminate the other contract. So there's two termination notices. And I'll consider those termination notices. So he's considering the termination notices the exercise of contractual rights. And I said I'll be brief. The over to page 363.
Well, 360 is interesting because it may be relevant to was there in inverted commas a variation, and it may be relevant to the nature of the complaint. Because what seems to have gone wrong in this case with the 20th of October letter on this is paragraph 3.25 on 360. I'll consider whether there's been a breach. Then it sets out the contractor shall comply with all relevant legislation, and then it sets out the legislation as 15A. But that isn't legislation that they must comply with. Regulation 32 says they must include in the contract things that are equivalent to 15A. So his error of law is to fail, his error here, the nature of the ground of challenge, he simply misread and misunderstood or omitted to have regard to Regulation 32, isn't it?
Well,
It's a public law ground.
well, I accept that para 15A wasn't legislation that applied automatically, it needed to be applied through a contract. And I'm going to go on to that on the variation, say why I think it was valid. Variation notice had the effect and point not raised and the bounds of the dispute and so on, and I've got those points to make. But yes, that in terms of why there's so much focus on the 28 October letter, that's the issue. It said,
You would say, but he's still interpreting clause 499 and what the phrase relevant legislation is. Mr. Sachdev would say, no, he's misunderstood Regulation 15A and or Regulation 32, and that's a classic public law error. But that's the difference between you, really, isn't it?
well,
No? Oh, sorry.
well, sorry, no.
It's better if it's no, because I got the wrong end of the stick, on the wrong stick. It's better just to say so.
Well, because the adjudicator was applying the mechanism, his role in the mechanism, which is to determine a dispute put to him. And the dispute put to him was whether or not there'd been non-compliance with cooperation duty. It was accepted that the cooperation duty applied, and it was said that the issue which both parties were talking about was whether there'd been cooperation or not, or whether there'd been breach of cooperation duty. That was the dispute. And in terms of clause 521 or whichever clauses, the dispute, which is the mechanism, the dispute referred was whether the cooperation duty had been applied with. The point Nadine was making to me is that the ground of challenge was not whether regard was had to Reg 32 or in the state of that nature, but whether the contract was varied, and that was a new point that was introduced through the judicial review. And we say, you know, what we say about that, and I'll come to that.
We'll come to that in a minute, dear. Anyway, sorry, you wanted to go very past 360 and you wanted to get to
363.
363, sorry, I took you out of your order there.
And the paragraph 3.41, we consider the cooperation breach. And I'm identifying the nature of what 341 onwards is looking at, what it's doing. 341, consider the cooperation breach, which is the dispute that has been referred to him for determination. 3.43, I consider the clause 572 applies. He talks about 571, 569, and so on. So he's working out the different contractual, identifying the relevant contractual provisions. And then 3.44.
I'm sorry, would it be possible to read 340 as well, just to put it in context?
Yes. Well, this is the point that we're going to get to on the variation. So yes, and I make the same point, which is the adjudicator was determining the dispute he's been referred to. That dispute is whether the cooperation breach, the cooperation duty had been breached, not whether it applied or not, because that was accepted by both parties.
I'm sorry, I just didn't hear that. What did you say?
The dispute referred to the adjudicator under the mechanism was one about whether the cooperation duty, which it was accepted applied, had been breached. And so, the issue of, well, it didn't apply or wasn't a valid variation, that was not the point referred to the adjudicator. That came afterwards. To the adjudicator, he was given a dispute saying both parties both parties were accepting is this duty applies, this duty in the terms of 15A, is it breached or not? That's what he's asked to determine, that's what he determines. So, and he gives his determination on that. The corporation duty is the terms of 15A, bearing in mind that the provision coming in from the statutory instrument is the contractual term, 15A. It's the duty. Has the duty been breached? Is the duty in 15A conveyed in the terms of 15A has been breached, yes or no? That's what he's looking at. That's what he's determining. And that's what we get in these paragraphs. Jonathan Haley is looking there, 344, he's assessing the contractor's argument that there's a breach by the CCG and he rejects those arguments. And then 345, he's finding there was a failure to comply. Now, the adjudicator's analysis, the point to take from this is the adjudicator was determining what was referred to him, and that concerned the contractual analysis of the parties' rights and obligations under the contract. To adopt the terminology of Walter Lewis, is the nature of the character, rights and obligations under the contract. If you also look at it in terms of the nature of the challenge, which is a separate matter, the nature of the challenge which he's determining is one of whether a particular duty was breached or not, and that's analysis. And now, looking at the challenge in terms of the challenge which is said to be amenable to judicial review, which is a separate step, you can see that, unfortunately, one thing we don't have in the bundle is the judicial review statement of facts and grounds, for whatever reason. But we do have, the grounds are conveniently summarised at core bundle page 200 in one paragraph. There's summary there, which is, I think, enough for the purposes of the submission I'm making, because the submission I'm making is a short one. Core bundle 200 is Ms. Justice Bourne's decision, paragraph 50, where he summarises the judicial review grounds of claim. As I said before, the grounds themselves are also relevant to look to in terms of the amenability question. And you can see 50, although the point was not taken for the adjudicator, the ground is there was no contractual obligation to comply with the PCN. So
no, it's very difficult without having the grounds, and I think we should have the statement of grounds. I actually think we should have the front of the judicial review form,
we've got that.
which is important, and I also think we should have the front of the form for the acknowledgement of service for the first respondent, because that will tell you whether they contest or don't contest or say nothing about. This is the summary guide, isn't it, of the first respondent. So it's quite important to have all the pleadings, because A, they're required to be there under the practice direction, and B, you need to have everything, not somebody's summary about everything.
Completely understand, yes. We have those three things in the bundle.
Yeah. Because one of the things I want to do now when I go back and read all of this was to see what the grounds of challenge actually were, and then whether or not it's interposed by Mr. Justice Bourne that wasn't ground one wasn't a point taken before the adjudicator. The other thing I'd like to know, and I'd have to read the summary of the decent grounds, is whether you objected to that point being taken before the High Court.
Absolutely.
You did.
Absolutely. I made a lot of, and that is in the papers. My skeleton is there, objecting, making all the same
No,
points.
I'm not interested in your skeleton. That's all very interesting. You can have written reams of skeleton. I want to know what's in your detailed grounds, and I don't know if I've got it there or not.
Well, I mean,
And do it now, do it after lunch, but you can see what I'm saying. It's not what everybody has said about everything, it's what was said at the time.
yes.
And I haven't, I mean, I might have read the detailed grounds, I can't remember now, life is very short, and no doubt for breakfast. But I haven't read them for a while.
Yes. I mean, the point was certainly taken and discussed orally in the High Court, but I'll endeavour to do that. But in terms of the documents, like Justice Lewis has mentioned, the one document he's asked for is the NHS acknowledgement of service.
It's the first page, because on the second page, but it's really the opening bits, because there the respondent is asked to tick a box. Do you contest the claim? Do you not contest the claim? And we've been shown letters and paragraphs.
294.
That's a 294,
In
isn't
the
it?
core bundle.
So
There's box 4 that's ticked. The defendant is a
294.
court or tribunal.
This is the first one. Yeah, and that doesn't say that they're contesting the claim.
Indeed.
Doesn't say they're not contesting it either. Just leaves it open. Yeah, thanks. I've got
Section-
that, so I
section
didn't worry
D.
about that then.
Well,
I'm just looking at the summary grounds. I think they're your summary grounds, are they? The 308. To see whether, yes, you say
well,
4A, you say the point was not raised, so that you cannot be said to have acted unlawfully for not addressing the point.
and while we're there,
Well, while you're there and while you're on that document, I was just checking the date of it. And the date of that document is October 21, isn't it?
I'm sorry, which document is more than one document we mentioned?
The acknowledgement of service 294.
That 18 October 2021, you can see
Yeah.
on 297.
And the solicitors are Radcliffe's. And it's dated up, whereas my lord has noted they don't tick the box that say they don't intend to contest the claim. And the court has received this morning a letter dated the 16th of July.
We also have what they said in the summary grounds, which I
Yeah.
took you to yesterday. And even the acknowledgement of service, 296, they're saying don't make any order for costs because we're a court tribunal, which is a pretty clear indicator that they're not taking part. Or not taking an active part to argue for either case. They certainly, that is the way it worked. In the end, what a lawyer for the NHSLA thought or didn't think at a particular point in time, I think ultimately,
Irrelevant,
well,
ultimately.
you've received a lot of other submissions which are perhaps more probative in some way.
I'm looking now at 309. You're not saying the point was not raised and therefore it can't be raised in the High Court. What you're saying there very subtly at 309 4A is the point was not raised in the adjudicator, so he cannot be said to have acted unlawfully for not addressing the point. Answer, not necessarily, because he may have made an assumption. Take a completely different example. If Dr. Shashikanth's surgery was in Jersey, and the adjudicator hadn't realised that, and he had no jurisdiction to make rulings about a surgery in Jersey, whether he took it or not, it would have to have been addressed. And the argument here is similar. The adjudicator assumed that the legislation had to be complied with, but he's wrong, the legislation doesn't have to be complied with. So even if he hasn't addressed it, the answer is he jolly well should have.
Well, there is
So
more.
does it solve this court from deciding whether there's been an error of law on the part of the adjudicator in aligning the legislation with the need to have a contractual variation?
It's relevant to the submissions I make on the raising of the issue of variation in the judicial review,
Right, okay, so we get back to that then, okay, yeah.
which I'll cover a bit.
We should come on to in due course.
I will, but while we're there, the document you looked at does go further in why this can't be raised, and I can take you to further indications of that, but including estoppel by convention, because estoppel by convention was argued, and I can show you where.
The grounds?
It's certainly it's certainly covered in the skeleton where it lay out. Well, the Lord, 74, page 324.
Yeah, okay. The other point, in fairness, that might be taken against you, and indeed it might appear in a judgment of the court, you haven't appealed on the grounds that the judge should have accepted that the point was never raised, and therefore the judge shouldn't have ruled, the tribunal shouldn't have ruled on it. Your respondent's notice is a slightly different point, I thought, was that not that the judge, Justice Bourne shouldn't have decided that there was an error of law because that wasn't raised. Your point is a slightly different one, estoppel by convention. So you haven't actually said his whole first part of the judgment is wrong because he was never should have looked at it.
I can show you what points were taken in the High Court and what was argued. We can talk about the bounds of the respondent's notice, but the arguments have been the same from the High Court to the Court of Appeal.
It's a very simple question, really, for our own purposes. Are you saying that we are assuming we are against you in amenability, and then we look at whether or not the judge was right on his conclusions of law? Because at the moment the judge said he's not amenable, but if it was amenable, as a matter of law, the tribunal got it wrong. Are you saying there's nothing to prevent us deciding whether he was right or wrong on variation? Or are you saying there's something that would prevent this court from now even looking at that? That's what I'm really concerned with. Is it a decision that's open to us, i.e. that the judge was right on variation and or wrong on amenability?
The respondent's notice is that he was wrong on the variation conclusion.
Yes. Sorry, I need to be clearer again then. Not that he was wrong because he got the law wrong, but that he was wrong even to look at it.
Both.
Right, okay.
Both. He was wrong in his conclusion on variation, and we essentially run the same points that were run before him.
He was wrong to look at variation. It was never raised, therefore there could never have been an unlawful decision. But if he was allowed to look at it, he was wrong in his conclusion.
It wasn't part of the referral to him, so it wasn't a matter which he was asked to determine.
Yeah.
It was a matter that was agreed between the parties that this duty was applicable, and the only issue was whether it was breached, and that was a positive statement made by the now appellant.
Yeah.
And also, the conclusion was wrong for the reasons we give around the mechanics of the 28th October, how you read the 28th October letter. If I can just have a moment to check. Yes. We also filed the skeleton argument with the respondent notice setting out what this point is, and that's at Core Bundle 39.
Yeah.
So in asking to be able to, sorry, not in asking, in putting this point as respondent, we set out.
Well, I need to be a pleader, but 34 and 38 are actually the grounds, not the arguments. And the grounds, you could say that in the little box on 6, you are raising the point. You say goes to appeal, we wish to appeal the order on different grounds. The respondent submits paragraph 3 should be upheld. The gentleman who was varied, and you say the determination was not based on an error of law. It's interesting whether that last bit followed on from the first one because it was varied, there wasn't an error of law, or in any event, whether there was or wasn't a variation, the judge shouldn't have looked at it. And then you go to the grounds of page 38, which I vaguely remember, and that doesn't seem to raise as a discrete point the fact that should never have been looked at by Mr. Justice Bourne, and therefore we should overturn his judgment because he shouldn't have been getting himself concerned with it.
51 to 53.
So I'm at 38 at the moment. Those are the grounds. And you say it was the same thing, was not based on an error at the end, but is that because of they were varied or because he shouldn't have looked at it?
Both.
I find that difficult.
So do I.
Very difficult.
Cleveland.
My lady was saying, and I was agreeing with her, that she finds what you have just said difficult to interpret in accordance with the grounds that they're set out.
You could just tell us in short order, therefore, and I'm looking on page 38, what you say about, I think it's little 2 there.
Yeah.
Just so that I can write it down.
Oh. The adjudicator's determination was not based on an error of law. That box is in light of the reasons we give for that, which are explained in detail in Core Bundle 5153.
So 2A then is there was a variation, and 2B is the determination was not based on an error of law. Quite separate from whether there was or wasn't a variation. It was an error of law not to look at it when it wasn't raised.
Sorry, I beg your pardon.
You're saying that little 2 breaks into 2 parts. 2A is the judge was wrong in his conclusion about variation. Full stop. He misread the letter of 28th of October. And 2B, in effect, is and the adjudicator's determination was not based on an error of law. And the reason for the 2B, as I've called it, is that he didn't make an error of law because this point was never put to him. Is that it?
Yes. Yes. It was not a matter that was put to him to determine, and that's explained more fully in the document which follows. Which
That paragraph.
it's Core Bundle 51 to 53, and I can show you 51, issue not placed in the jurisdiction. Okay, I don't want to get hung up on the word jurisdiction, but it's the bounds of the referral, and then 52.
We need to look at. Sorry, this is quite important. Actually.
Sorry, can I have the page
I
reference for
beg your
that?
pardon. Core Bundle 51.
So I think you would, from your point of view, you'd like to start at 4 on page 40. That's where you say the shouldn't have looked at it comes in.
Yes. Erden law, finding the adjudicator of Erden law on the issue.
And then you would say 24, because you say in the brackets, despite this not being an issue before the adjudicator.
Yes. And the
then the
details
next
where it's set
paragraph.
out is Bundle 51 and 53. Paragraph 52 is it wasn't part of the referral. So how can he He said to commit an error of law on something that wasn't referred to him.
Right.
.54 found the referral. And the estoppel by convention point is
No, that's not. That's fine. That's clearly there, is it? I think. Hang on, is it?
at page 53. Estoppel by convention, Chitty, Tinkler, and so on.
Okay. Yeah. Right. Okay.
You see 62 notes examined by judge below, despite the submissions being put. Submissions, reference to the skeleton, and I can show you, if needed, if it's appropriate, where that was all set out in quite some detail.
That's helpful. Thank you very much.
So, apologies, a box in the respondent's notice is I understand the focus on it, but it also comes with the more full setting out of what the error said is. So while it might use a short phrase, error of law, that's because the detail is provided at the same time. So it's not that we're slipping something in under the radar. I mean, we set it out quite fully, and it wasn't a surprise. This was also set out in detail in our skeleton report.
All of that came out of the fact that you'd taken us to the adjudicator's decision. So
I can be
where do we
brief
go
to
now?
finish that off. Right. So we were looking at the adjudicator decision. I'd actually finished taking you through that, and
Yes.
and the submission from that is that the adjudicator's analysis and what he was tasked with, what was referred to him, and what was looking at deciding was all on private law, rights and obligations under the contract, and that it was when we then went to the grounds of challenge. We then got into the 4 we've just been through. The point of all of this is looking at it from both perspectives of the decision under challenge, what Jonathan Haley wrote in his determination about what was referred to him. That was about private law rights and obligations. If you look at judicial review grounds of challenge against that, it's about decisions on private, it's about the working out of private law rights and obligations. So it's not he was discriminating against me from characteristic or it was nil motive or bias or anything of that nature. It was private law rights and obligations on both points. That is the nature of the nature or character of the decision taken. To finish off this point, there were a few cases that my friend ran through. I can just give you some bullet points on them because I'm conscious of the time. I don't want to spend the time by taking you through all of them because there are other things I should be doing. So, if it's acceptable to just give bullet points, you're taken to the case of SSP. That's one of the cases that was about an NHS contract. So its relevance to our case is limited by that, and I can't see in it any consideration of the issue of amenability anyway. So there are limits to what you can draw from that. Hafiz is another case that submissions made yesterday. We say that is a case that's materially very similar to ours and on an NHS contract. Amenability being argued and considered. One point that's made about it is that Mrs. Justice Stacey's comments, she said, were obiter. The one point I'll make on that is, if the finding is, which it was in Hafiz, that the challenge was not amenable to judicial review, but at the same time she determines it on its merits, then the issue of whether something's obiter or ratio, I think, may require a little bit of unpacking, irrespective of the label Mr. Stacey has given it, because she's decided it's not amenable, but if it's not amenable, well, what does that say about the other matter she's decided, which is the merits? You see the point? So one has to be careful about, even though the judge herself has used the term obiter, actually her decision is it's not amenable. So that rather is as operative, right? Because if it's not amenable, then the merit decision actually isn't the key point. Either way, though, I don't want to get caught up in technicalities. We say the case isn't properly distinguishable. There's an attempt to criticise it on the basis of the authorities it cites or its analysis, which takes me to the final point on this issue, which is the support ways line of authority, such as a couple of comments on and a couple of comments on Mauritius. So on the support ways line of authorities, yesterday Mr. Shashikanth was critical of the judge below, Mr. Justice Bourne, for relying on support ways in other cases, Krebs and so on, because he said that those were not relevant when you're dealing with challenges to a contracting party. And I don't accept the criticism of reference to that line of authority, because I think it in some ways misses what we get from the cases, which is that they properly do illustrate the limited role of judicial review with the character or the nature of the dispute is a dispute about contractual rights. And even when, and this is really, I think, a learning from this line, including Spallways and others, that even when that dispute about contractual rights occurs in a public services context, which you had there, that public services context doesn't transform a contract issue into a public law issue. Which leads me to the last case on nature character, which is Mauritius. And I'll do this very briefly. My friend discussed that case yesterday, and in covering that case, he suggested that it was a move away from Mercury Energy or this line of cases. Well, it's simply not the case. In fact, the opposite is true. I don't know if you've got copies already. We can always hand them up if you need them, but I might be quick if I give you the references. I'm happy to take you the paragraphs, and they are useful.
I'll give the references. I've got it in my head, but I haven't got it.
In that case, yes.
I didn't print it out.
The key point is the one case dealt with two types of decision. One was a regulatory approval by the minister, made in cabinet, announced by the Prime Minister, and the other was a decision by the minister on a specific agreement, it's called the implementation agreement. And in the reference, paragraph 62 has the consideration of the implementation agreement, which is the one that's comparable to our case. And paragraph 64, they talk about the type of challenge in a way that mirrors Mercury, fraud, corruption, bad faith, that analysis. And 66, they expressly approve, the proof of counsel expressly approves the Mercury formulation, the Mercury line of authority. Would you like it to be handed up? It's
I think you probably ought, yes.
I was going to say, I'd be grateful if we could have some
Thank you.
copies.
I'm in danger of creating too much mystery when actually I think it's relatively simple and might be quicker if you just see it.
Take from Jenny, do you
Thank you very much.
So I can shortcut this point by taking it to it quickly. If you can go towards the end, paragraph 62 is the decision of the Minister on the implementation agreement. '64, negotiating commercial contract on behalf of government. The Minister is not entirely free from constraints under public law, obliged to comply with base public law standards. Accordingly, decision on how to conduct negotiations for a contract is entered into may be brought into question by way of purely hypothetical example. If by purely hypothetical example he acted out of personal spite because he'd been bribed. The spite and bribery are heading towards or within the Mercury energy categories. And I say that because if you look at 66, there's the express reaffirmation of this. So my friend yesterday was saying, well, Mauritius goes away from this formulation. No, it doesn't. 66, we take the opportunity to reaffirm that guidance for corruption of bad faith.
It represents, as it says in the next bit, not because it's not amenable to judicial review, but because the nature of the discretion is such that you're unlikely to be able to find any additional public law, additional elements other than the ones that's been identified.
Well, yes. It's, again, I want to be careful not being hung up by labels. It's limiting the basis or grounds on which decision of this nature can be challenged.
At 68, law says leaves open, for example, the possibility of legitimate expectation.
Well,
If there
leaves
wasn't
open
one, yeah.
possibility, and the consideration of that is over because he said he leaves open the possibility. So this is the point I was making yesterday, that we're not saying amenability is an all or nothing. It can be about a limitation of the grounds, which is why we try to be careful in our discussion about using the phrase reviewable for error of law, because we say this is about the decision on the contractual rights. That's why. And just for completeness, so I'm not taking you to it, I said there are two types of decision in this case. And the other type of decision is considered at paragraphs 41 to 44. And at paragraph 43, the Privy Council are expressly saying that there's a separate matter, which is Mercury, and that's a separate question. It's 43 references the implementation agreement because there are two matters, which is the implementation agreement is what I took you to later on, which is the Mercury quote. And the Privy Council is saying that's a separate question and sort of parking that because it's dealing with it later. The only point in taking to this case is because it was said yesterday that this case is a move away from Mercury and what it says there in that line. That's simply not the case.
Okay.
I next wanted to make some submissions on election of consensual nature. Having covered in some detail nature, character, or what label we use for that. And we've covered a lot of this ground already, so I'm not seeking to repeat matters, but you know the points you make. There are two types of election: the election to use the NHS and non-NHS contract, the election to use the adjudicator route as the later election. In relation to a question which I think you, Legislator Asplin, put to me yesterday, which I'm not sure I completely answered, and that's my fault. I think by the time I'd started, I might have forgotten exactly what I said. I hadn't written it down. But I want to briefly explain how those two elections relate to one another. I think that might be part of what we find the question. In any event, it's important to know that.
Mm.
The first election, to have a non-NHS contract, is significant in two ways, and we rely on it for two reasons. The first, because it determines the nature of your relationship with the other party, as one giving rise to and governed by private law contractual rights and principles. And that's relevant to amenability in the way that, for the reasons I've gone through this morning.
Mm.
The adjudicator is making a determination about private law rights. The second way that election is relevant, and I rely on it, is because it gives the contractor, the GP, a choice as to enforcement, which the contractor would not otherwise have. That choice being whether to sue in county court or to use this procedure. And that second election to use the adjudicator dispute resolution mechanism, that's a difference between those with non-NHS contracts and those without. Because if you've got an NHS contract, you don't have that other option. Your only option is the adjudicator in terms of progressing your dispute, compared with non-NHS contracts suing the civil court. And that's the point of choosing a relationship giving rise to private law rights, because it's not a point of detail that you choose to have private law rights because you may wish to enforce them. And it's that aspect that should properly lead to different outcomes in terms of amenability, because here, GPs choosing a relationship, giving rise to private law rights, that being a voluntary element, choosing to pursue this mechanism rather than pursue his private law rights in the civil courts, that's a matter which only those with non-NHS contracts can have. And we say because of those matters, it's relevant to take into account what we see in cases, admittedly in other contexts, except context is important, but cases which contrast, which draw out this issue of consensual submission to jurisdiction as being relevant. And I want to be clear on what we're saying about this and what we're not saying, because I've been mistaken on this. On this issue of consent choice, however it's best phrased, we're not, there are two things we're not saying this is some strict rule. Because of an element of election, because of an element of choice, therefore, shut out JR. It's not that. And we're not suggesting that consensual submission to jurisdiction is the sole issue. What we say is that it's an important part of the multifactorial assessment. And while in some of the cases it's discussed in terms of this being a clear case of choosing contract, choosing consensual submission, therefore no JR. While we take the point or the issue, we're not saying it's that linear or binary outcome. Because obviously this is not the sole basis for jurisdiction here, and we accept the statutory scheme and other elements, and elements point towards amenability. We say it's part of the picture, and it's an important factor. But I don't want it to be said that, oh, you cited this case, which talked about consent, but that was one where it was the sole issue, so you're wrong. we have to take learning from cases with principles and apply them to our facts. I note the time, probably a convenient point to stop.
But I assume that you haven't finished on the election point.
No, I want to take it to 2 cases.
Yeah, okay. And how are you doing overall, Mr. Alban?
Fine. Second, longer than I had scheduled, but that's the nature of submissions. I will cut my cloth accordingly.
Well, we must be finished by 4:15. So, and obviously there have to be opportunities for replies. So you'll take that into account, no doubt. Thank you very much. 2 o'clock.
What bar is it?